Hi friends, in this video we are going to deal with the case synopsis of the important and latest Supreme Court judgments pronounced now in the area of constitution, consumer and labor laws. To know more about them, please watch the video fully. In the important judgment titled The State of Haryana through Secretary to Government of Haryana versus Singh and others pronounced on 7th April 2022, the Supreme Court has upheld the validity of the 1992 Haryana Amendment to the Punjab Village Common Lands Regulation Act 1961, which vests land reserved for common purposes by applying pro-rate cut in the village panchayat. The facts of the case would be that the 1992 Haryana amendments in the Punjab Village Common Lands Regulation Act 1961 were challenged before the full bench of the Punjab and Haryana High Court, which struck down the amendments so introduced. The decision was challenged before the Apex Court, which remanded the matter back of a recording of a crucial finding. It is thereafter the full bench of Punjab and Haryana High Court in Singh and others versus State of Haryana examined the legality of subsection 6 of sections 2G. The present appeals are directed against such order, and the order passed by the full bench dismissing the review application against the said order in the case of State of Haryana versus Singh and others. The counsel for the proprietors argued that though the land has been reserved for common purposes in the consolidation scheme under the East Punjab Holdings Consolidation and Prevention of Fragmentation Act 1948, but such land which is neither utilized nor reserved for any specific common purpose would revest with the proprietors. The Supreme Court has held that the land reserved for common purposes cannot be repartitioned amongst the proprietors only because at a particular given time the land so reserved has not been put to common use. The learned counsel for the parties could not point out any particular timeline during which the common purposes have to be accomplished. Since common purpose is a dynamic expression as it keeps changing due to the change in requirement of the society and the passing times, therefore once the land has been reserved for common purposes, it cannot be reverted to the proprietors for redistribution. Therefore, the impugned conclusion arrived at by the High Court is set aside as unutilized land is not available for redistribution amongst the proprietors. The finding recorded by the different benches of the High Court are clearly erroneous and not sustainable. The scope of the two provisions under the Haryana Common Purposes Land Eviction and Rent Recovery Act 1985 and Punjab Village Common Lands Regulation Act 1961 are different and distinct. Under the 1985 Act, the Gram Panchayat could seek eviction from unauthorized occupants. The management and control as of the land reserved for common purposes whereof vested in the Gram Panchayat in a summary way where the possession of the occupant was unauthorized. But if there is dispute in respect of the nature of occupation by the occupant or by the Panchayat, procedure under the 1961 Act alone can be resorted to, as Section 13A of the 1961 Act confers power upon the collector to decide the question of right, title or Panchayat in any land or movable property vested or deemed to have been vested in the Panchayat. Therefore, in case of a dispute about the right, title or interest in any land for or on behalf of any person, the remedy under 1961 Act alone can be exercised. This will include right, title or interest in all the three categories of land, that is, Samilat De owned by Panchayat, Samilat land vested in terms of 1948 Act falling in second category, and the land, the management and control whereof is vested with the Panchayat, land being within the permissible limits of the proprietor, the management and control of which vest with the Panchayat. Therefore, the amending act is valid and does not suffer from any vice of constitutional infirmity. The entire land reserved for common purposes by applying pro rata cut had to be utilized by the Gram Panchayat for the present and future needs of the village community, and that no part of the land can be repartitioned amongst the proprietors. Thus, the appeals filed by the state and the panchayats are allowed, and those filed by the proprietors are dismissed. Coming to the next important judgment, titled Experion Developers Private Limited versus SUSHMA, ASHOK, SHIROOR, pronounced on 7th April 2022, the Supreme Court has held that the consumer courts can grant relief to flat buyers who are agreed with the delay in delivery of the apartment as per the agreement. The facts of the case would be that the consumer approached the National Disputes Redressal Commission by filing an original complaint alleging that he paid a total consideration of rupees 2 crore 6,41,379 and possession was not granted even till the filing of the complaint. He therefore sought a refund of rupees 2 crores 6,41,379 along with the interest. The commission directed the developer to refund to the consumer for its failure to deliver possession of the apartment within the time stipulated as per the apartment buyer's agreement. Being aggrieved, present appeal has been filed with the issues posed for consideration, and they are whether the terms of the apartment buyer's agreement amount to an unfair trade practice, and whether the commission is justified in not giving effect to the terms of apartment buyer's agreement as laid down in the Pioneer case, whether the commission has the power under the Consumer Protection Act 1986 to direct refund of the amount deposited by the consumer with interest, whether the relief granted by the commission require any modification to serve ends of justice. The Supreme Court has held that the clauses of the agreement are one-sided and that the consumer is not bound to accept the possession of the apartment and can seek refund of the amount deposited by her with interest. The power to direct refund of the amount and to compensate a consumer for the deficiency in not delivering the apartment as per the terms of the agreement is within the jurisdiction of the consumer courts. A consumer invoking the jurisdiction of the commission can seek such reliefs as he or she considers appropriate. A consumer can pray for refund of the money with interest and compensation. The consumer could also ask for possession of the apartment with compensation. The consumer can also make a prayer for both in the alternative. If a consumer prays for refund of the amount without an alternative prayer, the commission will recognize such a right and grant it, of course subject to the merits of the case. If a consumer seeks alternative reliefs, the commission will consider the matter and will pass appropriate orders. This position is similar to the mandate under Section 18 of the Real Estate Regulation and Development Act 2016, with respect to which the court clarified the position in Imperia Structures Limited versus Anil Patni, reported in 2020 10 SEC 783. The freedom to choose the necessary relief is of the consumer, and it is the duty of the courts to honor it. The consumer in present case prayed for the solitary relief for return of the amount paid towards purchase of the apartment without a prayer for alternate relief. Recognizing the right of the consumer for return of the amount with interest and compensation, the Commission has passed the impugned directions. Thus, the Commission correctly exercised its power and jurisdiction in passing those directions. Also, the interest has to be paid from the date of the deposit of the amounts for the interest payable on the amount deposited to be restitutionary and also compensatory. The Commission in the order impugned has granted interest from the date of last deposit. This court finds that this does not amount to restitution. Further, the interest of the 9% granted by the Commission is fair and just, and this court finds no reason to interfere in the appeal filed by the consumer for enhancement of interest. Now we are going to deal with the important judgment titled Chairman-cum-Managing Director, Fertilizer Corporation of India Limited and another versus RAJESH, Chandra, SHRIVASTAVA and others, pronounced on 7th April 2022. The Supreme Court has held that ad hoc payment made pursuant to the interim orders passed by court does not form part of wages within the meaning of the expression under Section 2S of the Payment of Gratuity Act 1972 for the purpose of calculating gratuity. The facts of the case would be that the pay scales of the employees of public sector undertakings were revised. When the benefit of such revision was not made available to the employees of Fertilizer Corporation of India Limited and Hindustan Fertilizer Corporation Limited, the employees moved writ petitions in various high courts. At the instance of the Union of India, the writ petitions pending on the file of various high courts were transferred to this court. By an interim order, this court directed an ad hoc monthly payment to 4 different categories of employees as an interim measure, subject to the final outcome of the writ petitions, which stood transferred to this court. The issues that arise for consideration in the appeals are as to whether an ad hoc payment made to the workers pursuant to the interim orders passed by this court in a previous round of litigation could form part of wages within the meaning of the expression under Section 2S of the Payment of Gratuity Act 1972 for the purpose of calculating gratuity, and whether the ad hoc monthly payment made by the management pursuant to the interim orders passed by this court is liable to be treated as part of the wages within the sweep of the expression under Section 2S of the Act, especially in the light of the order passed in Sri Kashi Prasad Tripathi in CA number 4258 of 2015, dated 5/5/2015. The Supreme Court has held that the order passed by this court in the case of Sri Kashi Prasad Tripathi in CA number 4258 of 2015, dated 5/5/2015, would show that it has gone on the basis that the computation of the quantum of gratuity is exclusively within the domain of the authorities under statute, and that the High Court is not competent to interfere with the same. Therefore, the order passed in the case of Kashi Prasad Tripathi cannot be taken to have laid down any law to the effect that the ad hoc payment will form part of wages. The respondents therefore cannot really take advantage of the order passed in the case of Kashi Prasad Tripathi merely on the ground that the very same question of law was raised by the management in the civil appeal and thereafter in the petition for review and curative petition. At times, this court refuses to go into the questions of law when a single individual armed with an order in his favor from the High Court is pitted against the state. Whenever the state or the instrumentalities of state come up with appeals challenging small benefits granted to individual litigants, this court applies the test of proportionality to see whether the quantum of benefits granted to the individual concerned justifies the examination of the question of law at the cost of that little man from a far off place. The refusal of this court to go into the question of law in such cases cannot be treated as tantamounting to answering the question of law in a particular manner. It is a fundamental principle of law that a party who is in enjoyment of an interim order is bound to lose the benefit of such interim order when the ultimate outcome of the case goes against him, merely because of the fortuitous circumstance of the voluntary separation scheme coming into effect before the transferred cases were finally dismissed by this court by an order creating an illusion as though the lost drawn pay included this ad hoc payment. It is not possible to go against the fundamental rule that the benefits of an interim order would automatically go when the party who secured it failed in the final stage. Therefore, the orders of the High Court, the controlling authority, and the appellate authority under the Act holding that the ad hoc payment made pursuant to the interim orders by this court will form part of the wages or set aside. However, in view of the afflux of time and taking into account the fact that few employees are now no more, this court directs the management not to effect any recovery if payment has already been made to any of the respondents or their families.